Justice Sotomayor has our opinion this morning in Case 13-1175, City of Los Angeles versus Patel.
The Los Angeles Municipal Code requires hotel operators to maintain records containing certain information regarding their guests. It also compels hotels to make these records available to any officer of the Los Angeles Police Department for inspection on demand. The questions presented are whether facial challenges to statutes authorizing warrantless searches can be brought under the Fourth Amendment, and if so, whether the provision of the LA Code that requires hotel operators to turn over their guest registries to the police is facially invalid. We first clarify that facial challenges under the Fourth Amendment are not categorically barred or especially disfavored. First, two questions. Is the information that they've been keeping for 150 years the same? Because looking at the requirements, the early information was basically somebody's name, and I'm not even sure their address. But today's information has information that federal law doesn't permit to be disclosed, like driver's license, credit card information. I mean, federal law says you can't disclose that information. So isn't there a difference? It's not the same tradition over 150 years.
You are right, Your Honor, that the amount of information has increased.
What about my question about room 1204? You seem to say the police can wander all over the hotel.
So motels, for example, are out in the open.
Suppose in motels they can see what rooms have cars in front of them.
That's correct, Your Honor, and that's why the real-time observation is so key.
There's a whole lot of law enforcement techniques that could be used to combat the situations you're talking about.
But not nearly as effectively, Your Honor.
Well, since when has the Fourth Amendment completely been abandoned to how effective the proof that the police can get at a moment should be?
Well, Your Honor, that's not the test.
Oh, hell no!
They may be looking for the wrong thing.
Mr. Rosencrantz, why isn't this just like Barlow's, really?
In Barlow's, if there is an unsafe condition, there is an unsafe condition, and it's hard to see.
This is a facial challenge. Now, are there any or a substantial number of instances in which the application of this statute would be constitutional?
I would agree with that. It's just the hotel, and there is a range of situations in which different information is maintained in different ways.
Mr. Chief Justice, may it please the Court, we ask the Court to hold that the City does not need to go to the judge in advance and get a warrant, but instead that it merely needs to issue us a one-page subpoena.
Is it your position that there is no instance in which this statute and the implementation of it would be constitutional?
Here, there's no limit on when they can search, how often they can search, or the reason they can search.
What would be the nature of the objection?
The concern, when you have a scheme like this one that doesn't tell the officer how often or when to search, and is that the officer will do two things that are forbidden by the Fourth Amendment.
Thank you, counsel. The case is submitted.
Accordingly, we affirm the Ninth Circuit's holding that the provision of the LA Code that compels hotel operators to turn over their guest registries to police on demand is facially unconstitutional. Justice Scalia has filed a dissenting opinion in which the Chief Justice and Justice Thomas join. Justice Alito has filed a dissenting opinion in which Justice Thomas joins.